Hello everyone out there in Mr. Arnold's CLN4U class. Time for video number 2 in the snow day January 9th, 2024 series of videos. Very short one, it'll be too long, 2 videos long. Yes, first step for you is to navigate your way to Google Chat if you haven't already gone there, and open up the agenda, which is the session 12 agenda for today. Once you have the session 12 agenda open, you can scroll on down to where it says legal perspective and interrelationships. So legal perspective and interrelationships. There it is. In the last video, we looked at Creative Commons as a tool to find music and images you can use for your videos. And we are now going to look at the different levels of government involved when it comes to copyright, specifically from the lens of the Upper Grand District School Board. And we're going to look at how the relationships between case law. We looked at substantive law already at the federal level, and that was the Copyright Act. So that's your substantive law. And today we're going to look at case law and how that comes into a practical application. Yesterday, we also looked at copyright from a public law standpoint, and today we are going to look at that from a private law standpoint and how that plays into litigation, or so soon, connected to the game that we're going to play on Friday. Good stuff. Right, so you should have your CLN4U notes open and be ready to look at the policy for the Upper Grand District School Board that has to do with fair dealing and copyright. So I'm going to click on the link, and I would like you to open Policy 321, Copyright Fair Dealing. This is public knowledge. You can find this directly on the Upper Grand District School Board website. And you can see here that there is an official policy statement. And you can also see that there is a revision from February 2017 and March 2022. There's a reason for both of these revisions, and you're going to see in the matter of case law. So there was a major landmark case back in February, or back in 2015-2016. And in 2022, there was another landmark case brought by York University that there was a judgment upon recently at the Supreme Court level. If you'd like to look directly at the Fair Dealing Policy Statement and Copyright Statement, you can find it here as a PDF document. You can also find here the manual when you were looking at making copies as a teacher or an employee of the Upper Grand District School Board. Excellent. So first we have a local focus. So in your notes, you can make note of a local perspective. And you can go as far as to copy and paste or take a screenshot and or copy the link for the policy statement of fair dealing and copywriting here. Excellent. So that's the local perspective. Fantastic. Now, we are going to check that off. And as I was talking about, back in 2012, there was a case brought by Alberta's Education Ministry, claiming that the Canadian Copyright Licensing Agency, otherwise known as Access Copyright, had been overcharging the Alberta Education Ministry for making copies. So in that case, you can see here that we have an appellant. If the original litigation was brought by province of Alberta against access copyright, they would actually be called the appellant, or in this case, the applicant. So in litigation, they would be known as the applicant. And access copyright would be known as the respondent. So you bring an application in a litigation. But in this case, it's appellant and respondent because this was something that was appealed to the Supreme Court of Canada. So you can see down here, if you go to, one other thing I did not say is that if you look in here for the words Upper Grand, you can see that Upper Grand was one of the school boards that were represented in this. So this was a claim. This is an application or a claim made on the part of these school boards. What happened was that Access Copyright counterclaimed or countersued all of these school boards, and then in 2019, our school boards were forced to make photocopies of every single piece of information, every single Google Drive file that we had made for the last 3 years. So for 2019 back, someone sat in our photocopy room and made copies of everything that the teachers had done, and we had to share everything because Access Copyright was wondering how much of that was claimed under the proper copyright policy and under the Copyright Act. So it's something you can do. It makes litigation, it makes trying to sue someone a bit more complicated because they have rights to be able to countersue, to say, oh yeah, well, we're going to get you back. Now, if there are more than two parties in a civil case, you will also have something called a cross-claim. So one of the parties in what's called a class action lawsuit, which is what we're looking at here, can counterclaim against another party. So say the Waterloo School Board could sue the Upper Grand District School Board for some reason. I don't know why they would do that, but it's possible. So it gets more and more complicated. So that's our case law. That's the federal appeal, and that's the appeal to the Supreme Court. You can read through that decision from 2012 to see if that changed anything. But you can see here that it was first adopted in November 2012, but then revised because of the decision in February 2017. All right, I'm now going to close that. Unless you want to see the decision in this, you can do Control F and say decision, and you can find what the actual decision was. Okay. All right, cool. Close that. That's case law. All right. Now, what I would like you to do is I would like you to add to your notes the information under counterclaim in the following article. So if I click on this, open the CBC article, and do a Control F search with the word counterclaim. There it is. So you can see here what the school boards launched a claim for, and that Access Copyright filed a counterclaim for $50 million back. So the original issue being the school boards believed they were being overcharged for materials from Access Copyright, and Access Copyright said, oh yeah? Well, we think you haven't been paying and you've been making more photocopies than you're saying. You owe us $50 million. There you go. Alrighty. So the information that you want for your notes is this. So take some time to go ahead and do that now. Good. All right, so I will click that. And finally, from the provincial level, you're looking at Policy or Program Memorandum 157, specifically the direction that the Ministry of Education for Ontario gives to school boards when they are making their policy statements. So if I zoom in, you can see here that back in June 21st, 2013, that this was a reaction to address the case from 2012. So where the school boards challenged access copyright at the Supreme Court level, this particular policy was created. Now, the reason we look at this from these different levels of law is that you will be expected not only in your videos to provide proof of substantive law from the UN Sustainable Development level, but also from federal, provincial, and a local perspective as well. Excellent. Thanks so much for listening today. This concludes our lesson on interrelationships and copyright, and I will talk to you all very soon.